Welcome, everyone. Thank you for joining us today as we look back on what happened in patent law in 2019 and a preview for 2020, or as I like to call this seminar, 1 year of patent law in 60 minutes. I'm Jason Hoffman, a patent litigation partner resident in BakerHostetler's Washington, D.C. office. Presenting today alongside me is Mike Anderson. Mike is also a patent litigation partner resident in our D.C. office. Our program today will last an hour and is approved for 1 hour of CLE credit in California, Pennsylvania, Virginia, and New York. It is also approved in New Jersey via reciprocity. Credit will be provided in additional states as requested. During the course of the webinar, there will be 2 codes that will pop up on the slides, which one of us will read when that occurs. Please write down these codes. Once the webinar has ended, please look for a small pop-up on your screen. Click Close, and a brief CLE questionnaire will appear. Please make sure to answer all the questions, including entering the 2 codes. If you have any questions during the presentation, you can type your questions in the bar on the right side of your screen in the questions area. We will try our best to answer them at the end of the program, time permitting. If not, we will follow up with you after the webinar to answer those questions. Let's get started. The Federal Circuit was busy over the last 12 months, issuing approximately 479 patent-related decisions. Of these, 137 were identified as precedential opinions. Mike and I have read all 137 of those cases for preparation for this webinar. But during the course of the hour, we'll touch on about half of those decisions. For today's webinar, we've organized the cases into 6 topics, and we're also going to provide a short preview of issues we're looking at in 2020. So let's begin with our first topic, and our first topic is venue and jurisdiction. 2.5 years ago, the Supreme Court in T.C. Heartland decided that patent suits must be filed where the defendant is incorporated or where the defendant has a regular and established place of business. So what does a regular and established place of business mean? The Federal Circuit is still trying to figure that out. In the In Google case, Google servers were installed by third parties in the facilities of a third-party ISP in the Eastern District of Texas. And last February, the Federal Circuit decided not to weigh in regarding whether these servers constitute a regular and established place of business. As the Federal Circuit said, it would be appropriate to allow the issue to percolate in the district courts. Fast forward about a year, and the issue percolated to the Federal Circuit again. New plaintiff, but the same defendant, Google. On a similar writ of mandamus, the Federal Circuit held that a regular and established place of business in the district requires a physical, geographical location where the business of the defendant is carried out, and a regular physical presence of an employee or agent conducting the defendant's business at the alleged place of business. The Federal Circuit determined that the ISPs were not agents of Google, even though the ISP service contract allowed Google to request that ISPs perform certain services related to the servers. Here, the Federal Circuit ordered that the case be either dismissed or transferred from the Eastern District of Texas. So how has the T.C. Heartland case ultimately affected filings in the Eastern District of Texas? Well, in 2019, the Eastern District of Texas fell to 3rd for the highest percentage of patent cases. The District of Delaware is by far and away number 1. New on the top 5 list this year is the Western District of Texas. Judge Albright, who sits in Waco, has attracted a high number of patent cases. And as to the overall number of patent cases filed in 2019, then that number was 3,516. which is about as many as were filed last year. The downward trend over the last 5 years may be finally leveling off. Now we turn to the issue of jurisdiction, and specifically personal jurisdiction over a foreign company and a foreign university. A German company, Lebalken, had a license to enforce a Swiss university patent. The Swiss university had to give its consent before any cease and desist letter was sent, and Lebalken had the right to join the Swiss university in an infringement action. Lebalken sent a cease and desist letter, and the recipient of the letter filed a declaratory judgment action against both Lebalken and the Swiss university. The Federal Circuit held that the district court had personal jurisdiction over Lebalken because Lebalken sent the cease and desist letter. There was also personal jurisdiction over the Swiss university because it had threatened the suit by proxy. One other twist was that the Swiss university could not claim sovereign immunity under the Foreign Sovereign Immunities Act because it had engaged in commercial activity, here authorizing the cease and desist letter. Holy car seats, Batman. Does a federal court have jurisdiction over a state breach of contract claim because it involved a design patent? Patent owner of a design patent sued its licensee for breach of a license relating to a Batman car seat. To get into federal court, the patent owner had pled diversity jurisdiction. But the 11th Circuit found that there was no diversity jurisdiction, and the case got remanded. The district court then found that there was actually federal question jurisdiction because the case was, quote, patent infringement masquerading as a state law claim. The case went up to the Federal Circuit, which applied a 4-part test to determine whether there is federal question jurisdiction. The Federal Circuit found that a federal issue was not raised, was not disputed, and was not capable of resolution in federal court without disrupting the federal-state balance. They found that this was simply a state law contract case for past royalties, and as a result, there was no federal question jurisdiction. Now we turn to the issue of standing, but it's really a lesson about transferring patents. Imagine your company's patents are reaching expiration. There could be some untapped value in them, but you are not interested in suing your competitors. You decide to transfer all right, title, and interest in those patents to a non-practicing entity in order to monetize them. But you need some assurances. So the agreement that you have in place shields certain customers and business partners from any infringement suits without your permission. And the agreement prevents the new owner from transferring the patents to anyone else, like a competitor, without your consent. The result? Well, according to the Federal Circuit, that non-practicing entity that you transfer the patents to doesn't actually have all substantial rights to the patents, and therefore does not have standing to sue on the patents. And in this particular case, while the non-practicing entity, which was Lone Star Silicon Innovations, did not have independent standing to bring the lawsuit, the Federal Circuit did allow on remand Lone Star to ask the district court to forcibly join the patent owner, in this case it was AMD, as a plaintiff under Federal Rules of Civil Procedure Rule 19, mandatory joinder, in order to get standing. Mike?
Thank you, Jason. I'm going to discuss the claim construction and infringement cases that issued from the Federal Circuit this year. I'll begin with cases discussing whether claim preambles are limiting. First, in the Eco Brands, the Adrian Rivera Minez Enterprises case, the Federal Circuit affirmed a finding that a defendant was infringing. The defendant's non-infringement position had been based on a theory that the phrase, for use with a single serving beverage brewer in the preamble was limiting. The defendant argued that it did not sell a beverage brewer itself and therefore couldn't infringe. The Federal Circuit held that the beverage brewer merely provided a reference point to define the structure and purpose of the brewing holster and was therefore not limiting. In the second case that's on this slide, in Re Fought, the Federal Circuit went the other way and found that a preamble was limiting and that the PTAB had erred in rejecting claims because it had not considered the preamble a travel trailer comprising to be limited. The Federal Circuit found that the phrase travel trailer provided an antecedent basis for the subsequent claim terms. The next interesting case on claim construction is Amgen v. Amneal Pharmaceuticals, where the court considered how to construe a claim that begins with general comprising language, followed by more specific consisting of language to introduce several Marcouche groups. The claims were directed towards a pharmaceutical composition comprising several limitations, which then gave a weight percentage range from the group consisting of various enumerated binders and other components. The district court found that the presence of non-enumerated members of the Marcouche groups in the accused products took the compounds out of the claims. The district court focused on the consisting of language that was in front of the Marcouche groups. It believed there could not be non-enumerated compounds that have the same function as the compounds in the Marcouche groups. The Federal Circuit, however, disagreed, said the use of the term comprising at the beginning of the claim allowed other components that are functionally similar to those in the Marcouche groups, and the consisting of limitations were satisfied as long as the recited compounds fell within the claim percentage range. Now, there have been a number of opinions over the years that have found particular statements in a specification or prosecution history did not rise to the level of a clear disavowal. The Tektronix v. ITC case, however, is an example of where the court did find a disclaimer. The case here concerned the proper interpretation of a phrase wall console in claims that were directed to garage door openers. The administrative law judge at the ITC had found a disclaimer of consoles without passive infrared detection. The commission had reversed the ALJ, and resulting in a finding of infringement. On appeal to the Federal Circuit, however, the Federal Circuit then agreed with the administrative law judge, and it said, while disavowal must be clear, it need not be explicit and may be inferred from a limiting description of the invention in the specification. Here, the specification disclosed inventing a garage door improved by removing the passive infrared detection from the head unit to the wall console. The court also noted that prosecution history does not need to reiterate a disavowal that's already contained in the specification. The next claim construction case, which is DuPont v. Unifrax, really presents an interesting case where the Federal Circuit construed 100% by weight to mean something other than 100% by weight. The claim language was related to the inorganic refractory layer comprises platelets in the amount of 100% by weight. Based on the specification, however, which noted that the refractory layer may comprise some residual dispersant arising from incomplete drying, the court ruled that 100% platelets by weight means there is no carrier material, such as a resin, adhesive, cloth, or paper, in addition to the inorganic platelets. But there may be some residual dispersant arising from incomplete drying. Moving to infringement issues, there were several interesting cases on inducement of infringement that came out this year. Two of those occurred in the context of and the labels, both of which appeared to read the labels very narrowly in order to find no inducement. The first of these cases is the Grunenthal case, and here the labels were directed to severe chronic pain in adults. And the Federal Circuit noted severe chronic pain could include polyneuropathic pain, mononeuropathic pain, or nociceptive pain. The Federal Circuit held there was no inducement here because the ANDA labels did not specifically encourage the claimed use, which was for polyneuropathic pain. The Hznp medicines case is another ANDA case involving inducement. And here the Federal Circuit affirmed summary judgment of no inducement of claims that were directed to a method for treating osteoarthritis. The method involved applying the claimed formulation to the skin, waiting for it to dry, and then applying a covering such as sunscreen. The Federal Circuit concluded that the label's instructions that a user should wait for the treatment to dry before covering it with sunscreen did not actually instruct the user to cover the treatment with sunscreen or to wait for it to dry and then apply a covering as required by the claims. Instead, the Federal Circuit concluded that all the instructions were phrased as a warning and an if you do this, then do this, not as an instruction. On the infringement side, a number of decisions in 2019 also concerned the doctrine of equivalence, and more specifically, the applicability of exceptions to the general rule that narrowing claims via an amendment may be presumed to be a general disclaimer that precludes the application of the doctrine of equivalence. In the Pharmatech Solutions v. LifeScan case, the Federal Circuit affirmed a grant of summary judgment of non-infringement of claims that related to glucose monitoring systems. The Federal Circuit explained that the presumption of disclaimer may be overcome if the equivalent is not foreseen at the time, the rationale for the amendment had no more than a tangential relationship to the alleged equivalent, or there were other reasons the patentee would not have been expected to have described the infringing substitute. The plaintiff in this case had argued the second exception, that there was only a tangential relationship between the amendment and the equivalent. The Federal Circuit disagreed, however, noting that the original claims had been extremely broad and that several limitations had been specifically added to overcome rejections. The Hznp case, however, provides a counterexample where the second exception to the presumption that subject matter is disclaimed actually did apply. So here, during prosecution, the applicant had amended claims. And each of those claims had two different alternatives. Only one of those alternatives was modified during prosecution. The complainant at the ITC subsequently accused the respondent of infringing the alternative that had not been modified. The Federal Circuit affirmed the ITC's judgment of infringement under the doctrine of equivalence. It found that the prosecution history estoppel did not apply because the narrowing of the amendment had been peripheral to and was not directly related to the alleged equivalent. The Syngenta crop protection case, that's shown on the next slide, addressed the issue of infringement under Section 271G. Section 271G covers importation, offer for sale, sale or use of a product that's made by a process that's patented. The Federal Circuit found the district court had erred by concluding that 271G requires all steps of a patented process be performed by or at the direction of a single entity. The court noted that just because Section 271 requires one infringer for a method claim is not relevant here. Liability under Section 271A is based on the acts of making, using, selling, etc. But the focus of Section 271G is on the product. Moving to design patents, the Columbia Sportswear North America v. Serious Innovation Accessories addressed the infringement of an ornamental design of a heat-reflective material. You can see that design in Figure 1. The district court had granted summary judgment of infringement because it concluded that the defendant's pattern, which had incorporated the defendant's logo and resulted in some non-uniform waves, had only imperceptible differences from the claimed pattern. The Federal Circuit vacated and remanded that case, however. It felt that the district court had improperly resolved factual issues on summary judgment, it had improperly discounted the use of logo, and considered design elements independently rather than looking at the impact of the design on the whole. It also noted that whereas here prior art designs are close to the claimed design, small differences may assume far more importance. A number of interesting cases relating to the license defense also came out of the Federal Circuit this year. The first, Cheetah Omni, affirmed the district court's dismissal of infringement claims based on an implied license. It held that because the license covered the parent patent, there was a presumption that continuations were also licensed because they disclosed the same subject matter. If the patent owner had intended otherwise, it needed to make that clear. The court noted the fact that the license didn't specifically identify the continuations by number was not necessarily dispositive, as some of the patents were referred to by category, not number, in the license. With regard to the second case, the serious case, the main takeaway is that if there are facts in dispute regarding the scope of a license and whether it was terminated, those issues likely cannot be resolved on summary judgment, on a 12b6 motion. There were multiple disputed issues relating to whether an irrevocable license had been terminated by bankruptcy. The last case I wanted to address is Serta Simmons Betting v. Casper Sleep, and it concerned enforcement of a settlement agreement executed after summary judgment briefing had been filed. The parties had filed a motion to stay that informed the court of a settlement before the court ruled, but they were waiting on a first payment in order to execute dismissal. In the interim, the district court entered summary judgment of non-infringement. It reasoned that the parties had intended to keep the case open. On appeal, the Federal Circuit vacated the finding of infringement and held that an enforceable settlement renders the case moot, even where the parties have not yet performed the terms.
And this is our first CLE code. This is CLE code number 1. Please write this down. It's BH2020A. Again, it's BH2020A. Now let's turn to the latest series of cases where the Federal Circuit tells us what is and what is not patentable under Section 101. Let's start with a computer automated method that uses network monitors to detect suspicious network activity based upon the analysis of network traffic data and then generates a report of the suspicious activity. The Federal Circuit found that this invention was not abstract under the first step of Alice. The Federal Circuit explained that the claims are directed to using a specific technique, using a plurality of network monitors that each analyze specific types of data on the network, and integrating reports from the monitors to solve a technological problem arising in computer networks, identifying hackers or potential intruders into the network. Our second case concerns, which is also found to be patent eligible, concerns an invention relating to data transmission and an improved way that check data is generated so that the same defective check data does not continue to be produced for the same type of persistent systematic errors. Here, the Federal Circuit found that the claims are patent eligible because they are directed to a non-abstract improvement in an existing technological process, which is the error checking in data transmissions. The claims recite a specific implementation of varying the way check data is generated that improves the ability of prior art error detection systems to detect systematic errors. Our third case in the category of patent eligible claims involves a method for connecting a digital camera to a mobile device so that a user can automatically publish content to a website. Under Alice Step 1, the Federal Circuit here found the claims were, in fact, abstract. The asserted claims are drawn to the idea of capturing and transmitting data from one device to another. So as a result, the Federal Circuit moved to Alice Step 2. But under Alice Step 2, and at least at the pleading stage, they felt there was not enough in the complaint to take it out of being a patent eligible invention. Here, Cellspin specifically alleged that using HTTP at a specific location, here at the intermediary mobile device, was inventive, and alleged that establishing a paired connection before transmitting data was inventive. We have no basis at the pleading stage to say that these claim techniques, among others, were well known or conventional as a matter of law. So as a result, certainly this issue could come up later, and it certainly stresses the importance that if you're a plaintiff and you're asserting a patent and you think there's some potential question about 101, is to make sure your complaint is full of explanations about why it would satisfy Section 101. So now we move on to our first ineligible case, patent ineligible case. And this one where the claims are directed to the method for electronically processing paper checks, including capturing checks at the point of purchase, depositing money into a merchant's account, and the image of the check is matched up in a data file. The Federal Circuit found that under Alice Step 1, that the claims were directed to the abstract idea of crediting a merchant's account as early as possible while electronically processing a check. And the claims fail under Alice Step 2 because the claims do not purport to improve the functioning of the computer or affect an improvement in any other technology. The claims do not contain an inventive concept sufficient to transform this abstract idea into a patent-eligible application. And for another case, the charge point case, where we've got a thumbs down in terms of patent eligibility, this particular method or apparatus and method was for networked charging stations for electric vehicles. Under Alice Step 1, the Federal Circuit found that all claims were directed to the abstract idea of communication over a network for device interaction. And communicating over a network for that purpose has been and continues to be a building block of the modern economy, and therefore abstract. In applying Alice Step 2, the Federal Circuit found that the claims do not recite an inventive concept. The alleged inventive concept that solves problems identified in the field is that charging stations are network controlled, but network control is the abstract idea itself. Turning to our next case, the American Axle versus Neapco case, here the claims were directed to a method of manufacturing propeller shafts with a liner and tuning that liner to attenuate vibration transmitted through the shaft assembly. Now, under Alice Step 1, the Federal Circuit found that the claims were directed to the utilization of a natural law known as Hooke's Law without the benefit of instructions on how to do so. And I know everybody's dying to know what Hooke's Law is. Hooke's Law is an equation that describes the relationship between an object's mass, its stiffness, and the frequency at which the object vibrates. Under Alice Step 2, the Federal Circuit found that there was nothing in the claims that qualified it as an inventive concept to transform the claims into patent-eligible material. Now let's move to patents involving medical treatment. The first one is our natural alternatives case, and it involved a method of regulating hydronium ion concentrations in a human tissue by providing an amount of beta-alanine to blood effective to increase beta-alanohistine dipeptide synthesis in human tissue. The Federal Circuit said this was not abstract. They said that administering certain quantities of beta-alanine to a human subject alters that subject's natural state, and producing greater levels of creatine, which in turn results in physiological benefits for athletes. These are treatment claims, and as such, they are patent eligible. And that's something that we will see again in the next case. The next case is Endo versus Tevya, and it involved a method of using oxymorphone to treat pain in patients with impaired kidney function by using less of the substance than usual to achieve a similar level of pain management. The Federal Circuit found that under Alice Step 1, it was not directed to natural law or phenomenon. The claims in this case are directed to a new treatment for an ailment, albeit using a natural law or phenomenon. And so our last two cases in this subject and this area are, of course, are not treatment claims. And in fact, when it's not a treatment claim, the Federal Circuit goes in the opposite direction. In the genetic veterinary sciences case, the claims were directed to a method for genotyping Labrador retrievers to discover whether the dog might be a genetic carrier of the disease Hznp. Under Alice Step 1, the Federal Circuit found that the claims were directed to a patent-ineligible subject matter, namely the discovery of the genetic mutation that is linked to Hznp. And under Alice Step 2, the asserted claims do not recite an inventive concept that transformed the observation of a natural phenomenon into a patentable invention. The claims use conventional or known laboratory techniques to observe the newly discovered mutation. We see this dichotomy again in our last case, which is Athena versus Mayo. Now, this involved methods for diagnosing neurological disorders by detecting antibodies to a protein called muscle-specific tyrosine kinase, known as MuSK. Under Alice Step 1, the Federal Circuit found that claims were directed to a natural law, the correlation between the presence of naturally occurring MuSK autoantibodies in bodily fluid and MuSK-related neurological diseases. And under Alice Step 2, the claims were directed to a natural law because the claimed advance was only in the discovery of the natural law, and that the additional recited steps not only apply conventional techniques to detect that natural law. So on July 3rd of 2019, a petition for en banc review of this case was denied. What's interesting is that the overall vote was 7-5 in favor of denying at the Federal Circuit, There were 8 separate opinions where every judge signed on to at least one opinion. There is much disagreement about Section 101 cases at the Federal Circuit, especially as it relates to cases involving discoveries of natural laws. A cert petition was filed in this case, but it was denied by the Supreme Court on January 13th, 2020. Now we turn to invalidity. Mike?
Thank you, Jason. The Federal Circuit issued several interesting decisions on invalidity this year, and I'm going to begin with those that relate to Section 112. The Idenix Pharmaceuticals v. Gilead Sciences case, the court addressed the issue of enablement. The patent here related to claims for the treatment of HCV using a molecule described by a particular structure. The claimed structure had allowed for a very large number of nucleosides at a particular position on the molecule, even though the patent had only described having a hydroxyl group at that position. Notably, the defendant's accused product had fluorine at that position. The defendants argued the claim was overly broad and that the patent provided no guidance in determining which of the billions of nucleosides would be effective in treating HCV. The Federal Circuit agreed, found that a person of ordinary skill in the art would not know, without undue experimentation, which compounds would be effective for treating HCV. While the plaintiff had disputed the defendant's characterization of billions of potential compounds, even under its best case, there were still many thousands of compounds that were necessary to consider. There were only 4 examples in the specification, however, which the Federal Circuit said was insufficient given the broad scope of the patent. The Federal Circuit found the patent merely provided a direction for future research, not an enabling disclosure. Citing to Genentech, it also reiterated that it's not proper to rely on the level of ordinary skill in the art to try to fill in gaps in the specification, as the specification itself must supply the novel aspects of the invention. Moving to the issue of indefiniteness, the Hznp medicines was an ANDA case in which the Federal Circuit affirmed a finding that several terms were indefinite. Here, the claims were directed again to a method and formulation for treating osteoarthritis. The Federal Circuit affirmed a finding that 3 claim terms, impurity A, degrades less than 1% a year, and consisting essentially of, were each indefinite. With regard to the impurity A, the Federal Circuit found it wasn't sufficiently described. The patent didn't provide a formula, and the impurity was only discussed in one embodiment, and the Federal Circuit found it wasn't sufficiently clear to identify what it was. The plaintiff had argued that a person of ordinary skill in the art would understand impurity A referred to a specific impurity because only one component of the inventive formula had a known impurity. The court noted while there had been some discussion of chromatography testing in the patent related to that impurity, it did not actually identify the chromatography column used or the solvents used, so a person of ordinary skill in the art would not have enough information to determine what was described. With regard to the claim term consisting essentially of, the court noted that use of consisting essentially of in a formulation claim signals that the invention necessarily includes the listed ingredients, but is also open to unlisted ingredients that don't materially affect the basic and novel properties of the invention. Thus, the consisting essentially of raised 2 potential indefinite issues. First, are the basic and novel properties of the compound known? And second, does an unlisted ingredient naturally affect those basic and novel properties? Here, there were several properties mentioned, but the Federal Circuit took issue with the property of a better drying time, finding it was not sufficiently defined, and that made the term consisting essentially of indefinite. Turning to written description, the Ajinomoto case presents an example of where the written description of claims directed to a genus was found sufficient in view of well-known art, despite a limited description in the specification. The claims were directed to E. coli engineered to increase the production of tryptophan during fermentation. Sufficient description of a genus requires disclosure either representative of a number of species falling within the scope of the genus or structural features common to members of the genus so that a person of ordinary skill in the art can visualize and recognize members of the genus. The Federal Circuit noted the amount necessary will depend on what is known in the art. Here, although the patent only included 4 examples, the Federal Circuit concluded that was sufficient in view of the well-known art. An example of an inadequate written description, however, was provided in the Nuvo Pharma case. Here, the claims required an uncoated PPI pill in an amount effective to raise the gastric pH to at least 3.5. The specification merely mirrored the claim language without actually describing what amounts were needed to achieve the desired pH. The Federal Circuit concluded that the specification did not demonstrate the inventor actually possessed anything more than a mere wish or hope that the PPI could work, and it didn't demonstrate that he actually invented what he had claimed. The issue of inherency and obviousness determinations received a fair amount of attention from the Federal Circuit this year. In the Persian Pharmaceuticals case, the Federal Circuit affirmed an obviousness determination of 2 patents that were directed to treating pain in patients with hepatic impairment using hydrocodone-only formulations. The Federal Circuit held that the inherent characteristics of a formulation can be part of an obviousness analysis even if the characteristics weren't known at the time or recognized at the time. The Federal Circuit said it's not invention to perceive that the product which others had discovered had qualities they failed to detect. More recently, in the Hznp case that came out earlier this year, the court examined claims directed to degradation limits of a particular composition. Again, the inherent properties of the compound weren't recognized in the cited prior art itself. The Federal Circuit found that it was the extrinsic evidence could be used to demonstrate what's necessarily present in the prior art, even if the extrinsic evidence itself doesn't qualify as prior art. Interestingly, the court also noted the issue of whether a property is inherent in the prior art is a question of fact, and thus district court determinations are entitled to deference. Moving to motivation combined and reasonable expectation of success, the OSI Pharmaceuticals case addressed the issue of whether a person of ordinary skill in the art would have a reasonable expectation of success in a field where there's a high level of unpredictability. Here, the Federal Circuit reversed a PTAB decision holding claims directed to the use of a drug for non-small cell lung cancer as obvious. That the drug had been known to be effective against some cancers didn't create a reasonable expectation of success that it would be useful against NSCLC. The Federal Circuit emphasized the highly unpredictable nature of NSCLC treatments and noted that none of the references mentioned the use of that drug against NSCLC. Particularly here, the court noted that 99.5% of the drugs that entered phase 2 for NSCLC never obtained FDA approval. The Fox Factory case, which is shown next, addressed an issue that often arises in obviousness cases, whether there's a nexus between the claims and the evidence of secondary considerations. The patentee bears the burden of proving nexus, but is entitled to a presumption of nexus when the objective evidence of secondary considerations is tied to a specific product that embodies and is coextensive with the claimed features. If there are unclaimed features that are insignificant, a nexus can still be found. The PTAB here had found the claims non-obvious based on secondary considerations. It had concluded that the patentee had been entitled to a presumption of nexus. The Federal Circuit, however, disagreed and concluded that no reasonable fact finder could have found the claims coextensive with the products, because the products had unclaimed features that were actually covered by other patents and which had been described as critical to their performance. The next case, Liquid v. L'Oreal, concerns the secondary consideration of copying. The defendant here had received confidential access to the patent owner's pending application during deal negotiations and had allegedly, at least, used it to design its own product. The PTAB had found the patents to be obvious, but had refused to consider evidence of copying, believing it to be irrelevant under the Federal Circuit's iron grip barbell precedent. The PTAB interpreted the iron grip precedent as requiring copying of a patented product. The Federal Circuit vacated and remanded the case. It distinguished its prior decision in iron grip barbell, saying that the case only stood for the proposition that showing similarities exist between an accused product and a patented product does not demonstrate copying. The court held that the defendant's access to the patent application, coupled with the changes that it had made to its own product, could be evidence of copying. Moving next to design patents, the automobile body parts case addressed the issue of whether design patents for automobile parts were improperly directed to a functional design. The defendant had argued that Ford's design patents directed to auto parts, like a hood or headlamps, were functional because they aesthetically matched the design of the truck as a whole. The Federal Circuit disagreed, said we hold that, even in this context of a consumer preference for a particular design to match other parts of a whole, the aesthetic appeal of a design to consumers is inadequate to render that design functional. The next case, Arctic Cat, is the first of two interesting cases involving the issue of diligence in the period between conception and reduction to practice under Section 102G. The patentee here had submitted an inventor's declaration, including a series of emails, to demonstrate that he had conceived of the invention before the filing date of prior art and that he had been diligent in reducing the invention to practice. The PTAB said that there was no diligence because there was no detail regarding what happened in between, during the times in between the emails. The Federal Circuit reversed, saying that diligence need not be perfectly continuous, only reasonably continuous. The inventor here was reasonably diligent during the critical period so as not to have abandoned his invention or unreasonably delayed in its reduction to practice. The ATI Tech case, v. Iancu, similarly reversed a PTAB finding of lack of diligence, where the PTAB had concluded the inventor had not been diligent because after conception, but before reduction to practice, the inventor had redesigned the invention to include an unclaimed feature. Again, the Federal Circuit reversed, noting that diligence is not negated if the inventor works on improvements and evaluates alternatives while developing the invention. And finally, the last case on invalidity, Forum US v. Flow Valve, concerned a broadening reissue patent. The original patent claims had been directed to fixtures for holding workpieces when using a lathe. The original claims all required arbors to hold the workpiece. The reissue patent had added 7 claims, none of which included the arbors. Now, normally, in order to actually obtain broader claims in a reissue patent, the original patent must clearly and unequivocally disclose the newly claimed invention as a separate invention. Based on that, the Federal Circuit held the reissue claims here were invalid because the specification only disclosed an invention with arbors.
And now it's time to write down CLE code number 2. CLE code number 2 is BH2020B. Again, CLE code number 2 is BH2020B. And now we're going to move to a series of cases relating to PTAB practice. Oops. And our first case is the Arthrax versus Smith and Nephew case. And this is the case that the Federal Circuit, there's a lot of press about this one, that the Federal Circuit ruled that administrative patent law patent judges are unconstitutionally appointed. The Federal Circuit said that these judges are principal officers under the statute and would need to be appointed by the President with the consent of the Senate. There are only 2 PTO officers that are appointed by the President, and they do not have independent authority to review a PTAB decision before the opinions issue. The Federal Circuit, in order to solve the issue, decided to sever a portion of the statute with respect to how basically the statute had limited the way in which administrative patent judges had been removed or could be removed. And now it's basically, my understanding, it's almost sort of an at-will removal. This made them inferior officers and now made their appointments constitutional. With respect to the specific case for Arthrax, the Federal Circuit vacated the case and remanded the case to a new panel for it to decide. Petitions, I should note that petitions for panel rehearing and for rehearing en banc have been filed with respect to this case. The second big issue is about whether retroactive IPRs are constitutional. This was an issue that the Supreme Court in the oil states case had left open. So what is a retroactive IPR? A retroactive IPR would be an IPR that would be filed on a patent where the patent had been applied for prior to the creation of the AIA in 2012. The back history here is that with respect to inter partes reexamination, when that was instituted in 1999, there was those that only applied to patent applications that were filed after the law passed and didn't look retroactively. But with respect to IPRs, when IPRs were passed by Congress, they actually could apply to any patent having been filed at any time. And the Federal Circuit here held that the retroactive application of IPR proceedings to pre-AIA patents is not an unconstitutional taking under the Fifth Amendment. And of course, this a cert petition has been filed with respect to this issue, and we'll see if it makes it back to the Supreme Court. Speaking of the Supreme Court did issue an opinion earlier in 2019 on a patent law issue. It was the return mail versus the United States Postal Service. The issue was who has standing to file an IPR, a CBM, or a PGR. And here, the Supreme Court held that a government agency, like the Post Office, is not a person. And as a result, those agencies cannot file an IPR, a CBM, or a PGR. So a company is a person, but a government agency is not. Turning to the issue of the sovereign immunity, previously it had been determined that Indian tribes were not immune from PTAB actions, or for instance, with respect to, say, IPRs. And the question now is, what happens with respect to universities? And the Federal Circuit basically came to the same conclusions, that IPRs represent the sovereign's reconsideration of the initial patent grant, and the differences between state and tribal sovereign immunity do not warrant a different result than in the St. Regis case. Therefore, the Federal Circuit concluded that state sovereign immunity does not apply to IPR proceedings. Now we turn to the issue of indefiniteness in IPRs, where the statute itself doesn't identify indefiniteness as a area for which you can challenge a patent claim in an IPR. In this case of Samsung versus Presua, Samsung contended that the IPR statute authorized the PTAB to cancel challenge claims for indefiniteness, and the Federal Circuit said no. The PTAB does not have the authority to cancel claims due to indefiniteness in an IPR. Indefiniteness is simply another ground for invalidation in an appropriate form, which of course this is not. An IPR is not an appropriate form, but it still should not preclude the PTAB from analyzing either Section 102 or Section 103 arguments. This still leaves open the question of what the PTAB is supposed to do if they go to construe a claim with respect to an issue of 102 or 103, and they can't figure out what the claim term means. The Federal Circuit addressed two cases with respect to new arguments that were made by the PTAB during proceedings. In the In Re IPR licensing case, the case was actually on appeal for a second time. The first time had been up to the Federal Circuit, and the Federal Circuit had said that the PTAB had not identified a specific motivation to combine. So it went back down to the PTAB, and the PTAB found the motivation to combine. But this time, the PTAB relied upon prior art for the motivation to combine that was not part of the institution grounds. And when it went back up to the Federal Circuit said that the PTAB cannot rely on evidence related to grounds that were not the basis of institution. And this issue came up again in the Phillips versus Google case from January of this year. In that case, the IPR petition had raised two grounds of invalidity, both relying on a reference called the SMIL reference. The PTAB, though, exercised its discretion, and they added a third ground where they combined the SMIL reference with background art that had been discussed in the petition. The Federal Circuit here said that the petition determines the scope of the IPR, and that the PTAB is not permitted to add grounds that were not alleged in the petition. However, the PTAB may consider the general knowledge in the art to supply a missing claim limitation. So the PTAB can still look to other parts of the petition to fill in the blanks, but they cannot add an entirely new ground. And now we're going to turn to three cases from the Federal Circuit that involve the issue of a time bar. Section 315 provides a one-year time bar after being served with a complaint for being able to file an IPR. According to the Federal Circuit, served with a complaint for the purposes of Section 315 means presented or delivered in a manner prescribed by law. So the issue in this case is that the plaintiff had sued two defendants. One was located in the UK and the other was located in Cyprus. And they ultimately filed an IPR. And the question was, did service actually take place? And as a result, were they barred because they were beyond the 1 year time bar limitation? And ultimately, the Federal Circuit said that the IPR could go forward. And the reason was because, in the board's view, both the service in the UK and the service in the Cyprus had not been according to law. The board had concluded that the lack of signature and a seal rendered the UK service non-compliant with the Federal Rules of Civil Procedure, and the fact that the clerk did not send the summons rendered the Cyprus service non-compliant. As a result, this particular IPR was not time barred. What's interesting, of course, is that both defendants ended up appearing willingly in the underlying litigation, and the issue about whether or not they were served properly or not never came up. But here it was that the Federal Circuit saying it was okay for the PTAB to weigh in on that issue. In our second time bar case, which is the Power Integrations versus Semiconductor Components case, in this one, Power Integrations sued Fairchild for infringement. SCI entered an agreement then to merge with Fairchild. While the merger was pending, SCI filed an IPR against Power Integrations' patent. The merger with Fairchild then closed several months later, and it closed 4 days before the IPR was instituted. The Federal Circuit held that the IPR was time barred by Section 315B because Fairchild was a real party of interest at the time the IPR was instituted, because of course the merger had been concluded at that point, even though Fairchild was not an RPI at the time the petition was pending. And in our last case involving the time bar, this is an issue of waiver. Here, an IPR was timely filed in 2015. The petitioner subsequently merged with Itron and listed Itron as a real party of interest. And Itron would have been time barred from filing an IPR under Section 315. 7 months later, the PTAB found the claims invalid, and the patent owner raised the time bar issue on appeal. And the Federal Circuit held that Section 315 is not jurisdictional and can be waived. The patent owner had waived Section 315 arguments by not raising them at the PTAB. And now we turn to the issue of reply briefs in IPRs. Here in the Apple case, the PTAB had determined that Apple was raising a new argument of unpatentability in its reply by referring to a portion of a reference that was not described in the petition, and as a result, the PTAB refused to consider Apple's reply brief. The Federal Circuit disagreed, stating that Apple merely demonstrated another example of the same algorithm, and it was unreasonable to require a petitioner to address all possible permutations of an algorithm in its petition or risk waiver. The Federal Circuit also found that the arguments were also responsive to the patent owner's reply. The case was remanded back to the PTAB to consider Apple's arguments made in its reply brief. And now we turn to a case where you have to be careful what you decide not to appeal. In the PAPS case, it appealed multiple adverse PTAB decisions invalidating its family of patents. And shortly before oral argument, PAPS voluntarily dismissed 2 of those appeals. As a result of PAPS dismissals of the other appeals, PAPS arguments challenging the PTAB decision in this case were based on similar claim construction arguments and prior art issues in the other 2 cases. And as a result, those same arguments were barred in this case based on issue preclusion. The Federal Circuit found that issue preclusion doctrine can apply in this court to the Patent Trial and Appeal Board's decision in an IPR once it becomes final. And our last case in this category is about standing to appeal an IPR. Here there was no underlying lawsuits. And the petitioner argued, and the petitioner had lost before the PTAB, and the petitioner argued that it was injured by the PTAB's rejection of its invalidity challenges because the statutory estoppel provision would prevent it from asserting the same challenges in the future if the patent owner asserted them. However, the Federal Circuit said estoppel could not provide a basis for standing for appeal. Though the Federal Circuit did note that the court has not decided whether the estoppel provision would have prevented the petitioner here from being estopped in the federal court case, because the Federal Circuit actually didn't decide the issues on the merits. And now we turn to the issue of remedies.
Thank you, Jason. I'll start first with the Supreme Court decision in Peter v. Nantquist, or in Nantquist v. Yanku. The Supreme Court ruled that the Section 145 appeals from the Patent Office, the applicant does not need to pay the PTO's attorney's fees. While the statute says applicants must pay all expenses of the proceedings incurred by the PTO in defending a board decision, that does not include attorney's fees. The Arctic Cat case, which was decided just earlier this month, examined the impact of a failure to mark. Here, the patent owner itself made no products, but its licensee did and didn't mark the products. Prior to filing the suit, the licensees had stopped selling the unmarked products, however. The issue was whether damages under Section 287 begin at the date the lawsuit was filed or as of the last date of sale of unmarked products. The court noted the statute stated in pertinent part, in the event of a failure to so mark, no damages shall be recovered by the patentee in any action for infringement. The court noted that confusion remains because unmarked products may still be on the market. Now, the patent owner also argued that notice was not required here because the infringer's actual knowledge of the patent. And again, the Federal Circuit rejected that argument, saying the infringer's actual knowledge is not relevant because notice must be given by the patentee. Section 287 is about affirmative actions by the patentee. The court distinguished the American Medical Systems case that had previously been cited by the plaintiff, saying that's about when marking begins, not about ceasing the sales of unmarked products. The next case, the Aiton case, has to do with claims for fees due to disproportionate litigation. In this case, both the plaintiff and the defendant's expert had concluded that damages were no more than $687,000 after the court had determined on summary judgment that lost profits weren't available. The defendant then alleged that the plaintiff had not engaged in proportionate litigation and pointed to the fact that the plaintiff's expert alone cost more than $700,000, even though $687,000 was the most at issue. The Federal Circuit affirmed a denial of fees, however. It noted that the plaintiff could have gone to trial on injunctive relief alone since the defendant was a direct competitor, and it was within the district court's decision not to award fees, even in view of a weak damages case. The next case, IV, concerns the propriety of an exceptional case finding. The district court had awarded fees to the plaintiff based on the plaintiff's expert changing his opinions at trial regarding the meaning of a claim term, but the district court limited damages to those resulting from the changed opinion. The Federal Circuit remanded the case, noting that while a single act can be enough to justify an award of fees in some circumstances, the exceptional case analysis needs to be viewed in the context of a case as a whole. And so the district court needed to analyze whether that one act made the case as a whole exceptional. The next case, Blackbird, affirmed an award of $363,000 for nuisance litigation. The district court here concluded that the plaintiff had litigated in an unreasonable manner. Noted, for example, that even under the plaintiff's claim construction, there was no infringement. It also relied on the fact that after 19 months of litigation and after the defendants had filed for summary judgment, the plaintiffs then executed a covenant not to sue and sought to dismiss with prejudice. What's particularly interesting here is that both the district court and the Federal Circuit found that it was proper to consider the history of the plaintiff's nuisance value settlement demands, which started at $80,000, then went to $50,000, then $15,000, and eventually a walkaway of a settlement offer of $0. Federal Circuit stated the federal rules of evidence did not bar discussion of these settlement demands. Moving next to SRI International v. Cisco Systems, The Federal Circuit affirmed a district court's determination that the case was exceptional based on litigation tactics of the defendant. The district court provided a long list of what it believed were aggressive tactics, including maintaining 19 invalidity theories until the eve of trial and then presenting only 2, as well as pursuing defenses at trial that were contrary to court rulings or Cisco's own documents. The ThermoLife case is another interesting fees case. Here, the Federal Circuit affirmed an award of fees based on an inadequate pre-filing investigation, even though the court never addressed the issues of infringement, but instead decided the case on invalidity. So the moral of the story is an inadequate pre-filing investigation can be a basis for fees, even where it's not the basis of the ultimate judgment. The last case that we have on remedies is the EcoBrands case. That addressed an argument that's very often made in litigation, specifically that the district court's denial of summary judgment demonstrated that the positions that had been taken by the losing party were not unreasonable and that fees were therefore not appropriate. Federal Circuit disagreed. It affirmed the award of fees to the defendant for proving non-infringement of one patent, even though the defendant had been found to infringe the other patent. The district court had concluded that the plaintiff had unreasonably pursued the infringement claims relating to that patent. The Federal Circuit noted that denial of summary judgment is not dispositive on the issue of reasonableness of arguments, and noted that the district court had specifically stated that the plaintiff's arguments were questionable, but that they gave rise to disputed facts, which made summary judgment inappropriate. The court also distinguished its checkpoint systems v. Alteg security precedent, which says that a party is entitled to rely on denial of summary judgment as an indication arguments are not unreasonable. The court said this merely requires the court to consider the denial of summary judgment, not that the denial itself is dispositive.
And there's a quick 2020 preview. We've got 2 cases to quickly discuss. One is the Thrive versus Click to Call case. This is pending currently at the Supreme Court. Section 314D provides that a decision regarding whether to institute an IPR is not appealable. Yet the Federal Circuit held that a PTAB decision to institute an IPR after finding that the Section 13.5b time bar did not apply was in fact appealable. So the question is the decision appealable? And it was argued on December 9th, and we expect a decision by June. And lastly, there's the MLC intellectual property case. This one's before the Federal Circuit. A patent has expired. Plaintiff's damages expert was excluded. Without a damages expert, is the plaintiff still entitled to damages of no less than a reasonable royalty? And without a damages expert, should there still be a trial on liability? The Federal Circuit has granted an interlocutory appeal on these issues, and so we look forward to the Federal Circuit's ultimate decision on the case. And it looks like we've gotten to our full hour, so we'll answer any questions offline that you have submitted. I'm Jason. This is Mike. I think we just did 65 cases in 60 minutes.
Not too shabby.
Not too shabby, indeed. We thank you for joining us today. Please be sure to fill out the CLA questionnaire that will appear after you click close. We will also send an email to everyone with a link to a recording of the webinar. This concludes our 3rd annual Patent Law Year in Review. We'll see you next year.
Thank you.